Hi friends, welcome to this fortnightly monthly current affairs update. This is for the period 1st to 15th. Of course, we are on 18th today. So, till whatever happened yesterday, I have added it. Sorry about this couple of days delay. But we'll quickly go through what are, as always, I've classified it under two categories, Supreme Court and High Court observations, primarily Supreme Court observations and judgments, which are important, and other developments for other topics. So first is just a small point. Many of the high courts have represented, in the monthly update of October 2025, I talked about the judgment of the Supreme Court where it interpreted the service requirements, it interpreted the qualification requirements for being appointed as a district judge. And we had discussed this in the October monthly current affairs update. So we can please go and look at it. Now, many of the high courts have told the Supreme Court, please stay away from it because it is the domain of the High Court as per the Constitution. The Supreme Court has said, while hearing this, that our aim is not to interfere, but to lay down some standard guidelines which is uniform across the country. So this is being heard now. We'll follow it as and when the final judgment or any observation of the Supreme Court comes on this. But this is relating to what we discussed in the last fortnightly current affairs update. Supreme Court guidelines for framing of charges under BNSS. Again, this is not directly linked to polity per se, guys. This is more a legal issue. But UPSC does pick up these points. Based on this, they'll ask some static portion. So what is this about? This is about where the court needs to frame a charges. There are certain type of offences and we'll not get into those details and all. A charge sheet is filed by the investigating agency, which is usually the police. Or it could be the NIA, it could be the ED. Whoever investigates files a charge sheet against the accused. But there are certain crimes under section 251, those require charges to be framed by a competent court, which is a sessions court or an additional sessions court, whatever it be it is, right? Because these are criminal offences. And that needs to be framed within 60 days of the first hearing of the charge sheet in the court. There are charges which are not framed for months or even years together. And this is also a reason for pendency of cases. So the Supreme Court is considering framing a guideline so that this is strictly implemented throughout the country. This is something which you should be aware of. Then Saha guidelines on mental health. This was in the Sukhdev Saha case. Unfortunately, a 17-year-old committed suicide. And in that, this was a July 2025 judgment actually. But it was in the news recently, so I have picked it up. So the Saha guidelines is just like Vishaka guidelines for prevention of sexual harassment of women at workplace, which eventually became the POSH Act, Prevention of Sexual Harassment at Workplace Act in 2013. Similarly, the court has said till Parliament legislates a law, this guidelines will have legislative force. So what does it require? It requires that schools, colleges, hostels, all of them have a mental health support system. There must be a monitoring at the district level monitoring committee to be set up by the government. These are some important points about these guidelines, so we should be aware of them. And guys, this is an example of judicial activism again. See, this is linked to fundamental rights. They have said that right to mental health and mental support is part of right to life and liberty under Article 21. If that triggers a prelims question, right to mental health is classified as a fundamental right under, or as can be read as a fundamental right under which of the following articles? Article 21 is the answer for that. And for judicial activism in a mains question, this Saha guidelines can be given. No, Vishaka guidelines I would have given as an example in the book, in the printed book. Now this Saha guideline also becomes an example of judicial activism. This is a recent example. Vishaka guidelines you can of course quote, but you can quote Saha guidelines now. And guys, that is the beauty of Polity Simplified. Any such development is also captured as part of the monthly current affairs update on the Edge platform. So I'm making this for every viewer to get their insights and please benefit from it. But if you have Polity Simplified, you will get it on a monthly basis without fail, right? Conviction records to be part of affidavits even if subsequently acquitted. Right, the Supreme Court has interpreted, and this was relating to a local body election, but the same holds good for MLA election or MP election also. So if somebody is convicted, they cannot contest elections, of course. But if they are subsequently acquitted, they can contest elections. But that conviction and subsequent acquittal should also be part of their election affidavit to ensure transparency and accountability. To ensure transparency, people should be aware that, okay, this person was convicted by a lower court, acquitted by a higher court. So that is part of the recent Supreme Court order. Contempt against Telangana speaker. I mean, this is a never-ending issue. In KM Singh was the speaker of Manipur in 2020. 5 years ago, the Supreme Court, 5.5 years ago, the Supreme Court had said that speakers should decide on 10 scheduled disqualification petitions within a reasonable time of 3 months, unless there are exceptional circumstances, but never followed. Maharashtra speaker did not follow it for 18 months. Now, this Telangana speaker has not been following it for the last more than 15-18 months. In July 31st, after a prolonged delay, the Supreme Court said within 3 months you should decide. October 31st is over. Speaker has not even sent notices for this. The Supreme Court got really angry yesterday. It said you decide within 2 weeks, otherwise we will decide where you will spend your New Year's Eve. That is the kind of language they used. And it also said that in an earlier judgment, while hearing this case itself, reiterated again yesterday that while deciding on a 10 scheduled disqualification, the speaker acts like a tribunal. So he does not enjoy constitutional immunity in the sense, courts cannot direct constitutional authorities whatever they feel like, though they have started giving timelines and all because of the inordinate delays. But in 10th schedule, the speaker is not just a constitutional authority. The speaker is acting like a tribunal, deciding on a matter before them. So all tribunals are under the overall supervision of the Supreme Court because we are an integrated judiciary. So the court said, we can give you instructions, we can give you timelines, and you should follow them. Right? So this is something which is again in the news, which you should be aware of. And again, in the August monthly current affairs update, I had captured this, that the Supreme Court has said that within 3 months of reservation for verdict, they should be delivered by High Court judges. Otherwise, the process they had put in place, which I have captured in August 2025, few days back, the Supreme Court again reiterated that there must be a dashboard which gives the date of reservation, when the judgment was delivered, to bring in more transparency and accountability in High Court judges. So these are linked to Supreme Court judgments and observations, which are of importance, which are of relevance for polity, right? Then some other miscellaneous topics. Today, any political party is to be registered with the Election Commission under the Representation of the People Act. And then they get recognized as a state party or national party. All that is covered in section 23.3 of our book. But now there is a public interest litigation which has been filed, which has been admitted by the Supreme Court. Again, no final order in this. We will follow this. But guys, these are points which you can always, let's assume that the final order doesn't come for this even after 1 year. It may not. But this point can be mentioned in the mains as an answer. Understand, guys? Some of it will be directly asked in prelims, like Saha guidelines, right to mental health is part of which article? That could be a prelims question. Or BNSS, framing of charges, some statement from that comes. That could be a prelims question. But Saha guidelines can also be quoted in the mains for judicial activism. Right? The delay in decision by speakers is a point which can be written when any question comes relating to the speaker in the mains. So guys, this is the reason for following monthly current affairs update. You should do it thoroughly. And I also give the relevant section of the book in this. So the aim is when you read it, you revise it, but you also make a note of it in that section. Refer monthly current affairs update of November, or just don't even write November, refer and all. November 2025. Then you know that, okay, some point relating to this is in the monthly current affairs update of November. So you go back again, last minute, revise one more time. Then this is an additional point you can write. Right? But there is no guideline today for the regulation of conduct of political parties. Of course, there are laws, there are model code of conduct, all that is different. But proper regulation, financing, internal elections, nothing is there legally as a law. So there is a plea before the Supreme Court filed by an advocate, Ashwin Upadhyay, who has said that under the Representation of the People Act itself, amendment should be made to bring more guidelines for regulating the functioning, the ensuring the inner party democracy, right? So notices has been sent by the Supreme Court to the ECI, to the Center and to the Law Commission. Let's wait and see how this develops further. Right to vote is a statutory right. That's a correction you need to make in the book, guys. I've even written a full page or a half a page text and context article on that. I've told you that. But freedom to of voting is part of your freedom of expression. That is what the Supreme Court, that is what the center has told the Supreme Court. Now, this is linked to nota. See, let's say if there is only one candidate for a Lok Sabha or a legislative assembly seat, then that person is declared elected without any poll, because there's only one candidate. That is what the RP Act section 53 says. If the number of candidates do not exceed the number of vacant seats, then no poll is required. All of them will be declared unopposed. But there is a PIL which has been filed saying that for Lok Sabha and Assembly, even if there is no other candidate, nota should be put, so that people can go and choose between that one candidate and nota. And for this, notice has been issued, and part of this center has said, look, nota is not a candidate. Only when a poll comes under the regulations of the Representation of the People Act, the statutory right to vote kicks in. Freedom of expression is part of your fundamental right. And freedom of voting, whom you want to vote once you go to the polling booth, is part of that freedom of expression. But it arises only when a poll is held, and poll need not be held when there is only one candidate. That is how the center has explained it, and we'll also follow this case law also in future. And guys, probably the most important part of this entire period is the DPDP rules that have been notified, right? I just went through it quickly yesterday. I have updated all the points. Any further refinement of this, I'll carry it in the next fortnightly updates. But there are pros and cons of this DPDP rules also. That is something which in subsequent sections we will discuss. But basically, a digital person protection board has been constituted. It will consist of chairperson plus 4 members. There will be a search cum selection committee for the chairperson, and then for the members separately. There will be consent managers who will have to be appointed, who allow individuals to give, manage, review, and withdraw their consent. And whoever has to act as content manager is to be registered with the DPB. But these are going to kick in. There are various provisions which are going to kick in between 12 to 18 months. But this DPDP rules, please go through this. Monthly current affairs update again in the Edge platform also it will come. But make a note of all these points. These are important. Data fiduciary is aware of a data breach. They should communicate it to the data principal. Data principal is us who give our data. Data fiduciary is government, Meta, Google, X. All these are data fiduciaries who handle our data. If there is any breach of our personal data, there must be an immediate communication, and the detailed report should come within 72 hours. Personal data should be retained for 1 year for specific purpose, for investigation and other things. And for large companies, large platforms, they should be erased after 3 years. So guys, these are all small points which can be tested in prelims also. So we should be aware of them. Data fiduciaries should obtain parental consent. But this also kicks in after, I think, 18 months, if I'm not wrong. Parental consent for using children's data. And data fiduciaries can transfer data outside India subject to central government guidelines. So these are the most important points of the DPDP rules. And if there is something else more that I want to add, I'll add it in the next fortnightly update. So these are the important current events for the fortnight, November 1st to 15th. I'll see you again with the next fortnightly update towards the first week of December. Thank you.